Welcome to the debrief, everyone. Let's begin with the trial of a Florida man accused of killing his wife and business partner. Mark Sievers, charged with being the ringleader behind the murder of Dr. Teresa Sievers. A colleague found Dr. Sievers beaten to death with a hammer inside her own home. Husband Mark Sievers is on trial right now. Co-defendant Curtis Wright pleaded guilty and testified both against the husband and the third co-defendant, Jimmy Rogers. Rogers is in prison after a second-degree murder conviction. The day began as the judge asked, as usual, if jurors had been exposed to pretrial publicity about the case. Two said they had. Here is how the judge handled the first juror.
We were released early yesterday. I didn't know whether I needed to go back to work or not, so I was Googling the jury rules for a juror, whether you need to go back to work after you've been released early for the day. And for some reason, I got to a page and it had 4 rectangles on it. And in the lower right-hand rectangle, I saw the name Jimmy Ray Rogers. I immediately closed it down because I said, oh gosh, I shouldn't be seeing any of this. Immediately closed it down, shut off the computer, and came over to the jury assembly office where I asked one of the clerks what I needed to do. I knew I needed to raise my hand this morning. But I just needed some confirmation not to worry about it all night last night. So, and I know this is very minor. All I saw was the name Jimmy Ray Rogers. I don't even know what website it was, but I didn't see anything more than that.
You did exactly what you're supposed to do. You just,
Okay.
if it's someone talking, you tell them I can't talk and you walk away. And if it's something like that, just close it.
Now to the discussion involving the second juror and conversations at work.
And ma'am, tell me what happened. And you know, as long as you're telling us, you don't have to be worried about anything. You're fine.
I went to work yesterday because it's the holidays and people are asking for time off, so I wanted to be honest and not just go home and take advantage of the day. You said we weren't sequestered, and it was just, people are trying to figure out stuff. I just say, I can't talk about it, but I woke up this morning and I'm thinking, you know, am I putting the case at jeopardy because I want to be a nice person and, you know, show up. I'm not talking about it, but people can figure stuff out.
Well, I mean, the key is if you're not talking about it, if people are telling you what they think about it, then you need to tell them you can't talk about it and walk away.
No, they're not telling me what they think. I did hear somebody say they were following a case, but like I say, they were all happy to see me, and I'm just like, you know, they know something's going on. I can't talk about it, but I felt myself like, you know, maybe I've messed up the integrity of what I'm supposed to be doing.
Attorneys Mike Koribanics, Michael Bryant, and Ecleynne Mercy are joining us now. So, Ecleynne, how did the judge handle that in your opinion? Was that the right way to handle both of those instances?
Yeah, I think he did an excellent job on just keeping the jurors just calm, cool, and collected, doing an assessment, like a proper assessment on what actually was done and what information was actually, you know, seen or not seen. So I think he did an excellent job.
The jurors taking their duty seriously, and the second juror just saying, hey, look, I tried to do what I thought that was the right thing, help out at work because I had half of a day, and then people are bombarding me trying to figure out what's going on. So the fault is actually with the coworkers, right, Michael Bryant?
Well, you know, that's they like gossip. They like to find out what's going on, and here's an insider. And I don't think they mean anything, you know, no ill will, but they put her in a horrible position, and she handled it great. If the other 8, 9, 10 jurors are as good as these two, they got a great panel.
Yeah, and they're a little bit nervous, but they're coming forward telling the judge, look, here's what happened. I think they were believable. Mike Koribanics, who Googles whether they need to go to work? Don't you just call the boss up and say, should I come to work today?
Well, if you've got an employee who does that, you're really doing a good job as their boss, because most people take that as a vacation when you're on juror duty. But you shouldn't be Googling it. You should always, there's always a contact person in the jury room or things of that nature to give you the proper guidance.
So let's go back to the original question here. Mike Koribanics, did the judge handle this the right way? Because some people might say, well, you know, the first one saw a name on a screen, shut the computer down, that was the end of it. The second juror may have been actually involved in some kind of a discussion It doesn't sound like there was pressure. It doesn't sound like there were facts discussed, but did the second one get a little bit closer to a problem area, in your opinion?
Well, you're always very cautious. I think this judge did a great job because he's got a very amicable way about him, and I think the jurors are confident. So I think they're not going to be as hesitant or afraid should issues arise in the future in this case, and that's important.
Michael, Bryant, do you agree with that assessment?
Oh, yeah, and I think the second juror that spoke about the coworkers, I felt sorry for her. I mean, she was stressed over this really non-event that could have been important. She was so concerned that she was going to screw up the trial. That was admirable.
I think so as well. You know, I mean, and she didn't know it was an issue. She brought it up. She said, I don't know if it's an issue. I don't think it's an issue, but at least I'm disclosing it. And that's exactly what these jurors should have done. Testimony today now revolving around cell phone records and that code word other, which admitted killer Curtis Wright said he and the defendant used to signal that their conversations needed to switch from their regular phones to their disposable burner phones.
The 858 drew my attention because the 404 that was mostly all the calls he talked to was the 858. So, and that drew my attention that it was a California number, the 404 who was in the scene of the homicide and up in Missouri was talking to this California number. So that drew my interest. Since I knew there was communication on the 7th, I looked at the Cellbrite downloads of his text messages to see if there was any communication, and he sent a text to Mr. Wright saying, since neither one of us are likely to carry both with us, whenever you want to use the other one, just text me, other, quote, other, unquote, and then when I can, I will call. So this kind of sparked my interest of maybe trying to communicate on the burner phones.
Now, that message was sent at what time on May 7th?
It was sent around 3:45. This was after the activation.
On cross-examination, the defense suggested that proof of communication, that communication happened, does not mean the state proved that Mark Sievers and Curtis Wright actually conspired to kill Dr. Sievers.
When were you first asked to participate in this investigation?
That was in January, February of 2016.
Okay, and at that time, were you aware if they already had Dr. Sievers' cell phone in evidence?
No, I did not.
Okay. Did you ever do any requests for the geolocation data from Dr. Teresa Sievers' phone?
No, I did not.
Okay, so can we tell in any of these pings how or if Dr. Sievers was in the vicinity of that 858 number? Can you tell?
No.
Okay. Is it possible for us to determine or discern any of the content of these voice calls between the prepaid phones?
Such as text messages or, I don't know.
Anything.
Just all I have is documentation that they talk to each other or where they ping from. I don't have text or voicemail.
Do you know what they were talking about?
Oh, absolutely not.
Okay.
The prosecution also called cell phone records experts to track for the jury how defendant Jimmy Rogers traveled from Florida back home to Missouri after the state says he committed the crime.
Can you tell us what we see on State's Exhibit 114? This information continues to show the historical precision locations of the phone attributed to Jimmy Rogers on June 29, 2015. As we saw on that previous exhibit, right around midnight of that morning, the phone is in northern Lee County. We see a general northern movement along I-75 throughout the day, here at 7:41 a.m., here at 12:19 p.m., here at 2:44 p.m., and here at 5:31 p.m. And I see multiple phones. So have you created a text box for every time the phone, you had historical precision location data, or have you just created text boxes for some of the historical precision location data?
I chose text boxes for some of
the data points. If I had put one for every single time we see a red phone, this map would have been unreadable and covered up completely by dates and times.
On cross, the defense pointed out that GPS tracking is way more accurate than cell phone tracking.
Couldn't say exclusively.
Would you agree with me, however, that if we look at a GPS, which comes from satellite data, GPS data tends to be more accurate as far as determining geological position?
I don't know enough about GPSs to say exactly where their data comes from.
Okay. Can you tell me when Mr. Rogers' phone began to travel north on this, on 112?
Looks like 11:38.
So, am I also correct in saying that the route of travel tracks very narrowly to I-75?
What route are you asking?
The positions track narrowly along I-75 in this top portion. Would you agree with that?
Yes.
Let's go back to our three attorneys now, Ecleynne Mercy, Mike Koribanics, Michael Bryant. So Michael Bryant, what's the defense trying to do here? They've got the GPS data, they've got the cell phone data, the state that is, I'm speaking about. So is the defense trying to say that the GPS is much more precise and doesn't put one of the other defendants at the actual scene of the crime? Is that what they're trying to go for here?
That is as good a guess as any. I don't know. I mean, if I step back and look at the original premise for this road trip, it was Curtis Wainwright going down to Sievers' place to work on the computer. So great. So there's the route they took. That's not disputed. The reason, of course, why they took the trip is disputed. So I don't know why you're beating this thing to death just to show that, hey, GPS must be accurate.
Ecleynne Mercy, insight on this? Is this making sense to you as a defense tactic? I mean, the bottom line, because here's the bottom line. If I'm sitting on the jury, I'm looking at it and I'm saying it puts them in the vicinity.
You just helped the prosecutor. Like,
Of course.
you just solidified something for the prosecutor. That's something that you would have left to your closing and been like, we don't have GPS, coordinates, and GPS would have been a little bit more, like we could have done that. But right now, you just have this woman saying, yeah, exactly. They were going this place. And this is absolute proof that they were going there. So I don't know why they did that.
They're in the area, remember, Ecleynne, they've got the GPS that the one co-defendant borrowed from one of his friends or neighbors or whoever it was, and then said, oh, I don't want to give it back to you. Can I buy it because it has a record of where I've been? That's what the person who actually owned the GPS testified to. Mike Koribanics, I think the evidence is stacking up in the prosecution's favor here.
Yeah.
Well, through a lot of help of the defense. I think the best cross-examination here would have been no further questions. I have no cross-examination, and Madam Witness, I hope your GPS works on your way back to Missouri.
Yeah.
Well, look, I'm not going to get into that. I lived in Missouri for about 2 years, and the pronunciation is oftentimes both double-sided there in that state. And look, we're going to move along here. We've got a lot more to talk about on the debrief. Other than the Sievers case, we're going to break down actor Bill Cosby's bizarre statements from behind bars this week. Plus, is dismemberment the new defense to murder charges? An awful New York case seems awfully similar to something we here have seen before. A convicted sex offender beat a murder charge in Brooklyn this week after he admitted to hacking up the victim's body. Prosecutors accuse Somorie Moses of forcing his girlfriend to be a prostitute. Moses took the stand and said he kept her head, hands, and feet in his freezer, but that he didn't kill her. Prosecutors wanted a murder conviction. The defense told the jury that what Moses did, quote, shocks the conscience of everybody in this courtroom, but that the dismemberment did not prove a murder beyond a reasonable doubt. Prosecutors only scored a lesser homicide conviction on this one, along with a conviction for concealing a corpse. If the facts of that case sound eerily familiar, they are. We covered a virtually identical case in Florida. In that other case, James Scandarino Jr. beat a murder rap by saying he found his father dead. Scandarito, the defendant, says he cut up his father's corpse and hid part of it on a golf course so that the police wouldn't learn about drug involvement. The father, the victim, was a retired judge. Here's how the defendant's son testified.
I take a garbage bag and I kind of cover the part that is being dismembered. So when the arm, let's say, is finally dismembered, it's kind of falls into the garbage bag.
And with those garbage bags individually, what did you do with them?
When I eventually ended up putting them all into 3 suitcases. Maybe it's not, physically strenuous, but it wasn't. It was not something that it was a quick. It was a long time. I would take frequent breaks, go out through the garage door, into the outside of the house, the side of the house, smoke cigarettes, and just, wish that this nightmare wasn't happening.
It didn't have to happen. Like the cigarette makes it easier. Let's go back to the panel now. Michael, Bryant. So here's my question. Is this the new defense? Get charged with murder, admit to dismemberment, and then say, oh, well, the government can't prove cause of death because the body's been dismembered. Is this like the new thing here?
I call it the Scandarito defense, which is my favorite kind of Dorito, the Scandarito.
There's a barcode for that.
I think the jury in Scandarito case had a little more to cling to maybe than in this more recent case against Mr. Moses. There was I want to hide the drug use. I don't want to be caught by the cops with the drugs. So my dad died of natural causes. Therefore, I had to cut up his body to hide the drug activity. Outlandish, yes, the jury clearly bought it.
Look, Ecleynne, I'm not suggesting one defense necessarily caused the other, but there certainly is correlation here. I'm not saying there's causation. In the New York case, the defense was that someone else hired the victim's prostitution services, and that the defendant swooped in, fought off the attacker, but it was too late. The victim died, so the defendant just hid the body, and the jury believed that.
Yeah, but that's a growing defense. Remember the Brooke Richardson case, the killer cheerleader, who baby apparently was born dead, but let me throw the baby's body in someplace and just leave it there. So I didn't kill him, but I just did something with the body. So it's a new tactic that's being used. You could see it across state lines. It's working. So the prosecutors have to get on the better foot, because these defenses are actually working and making sense to juries.
So, Ecleynne Mercy, you're taking notes on this in case you need it for a client. Mike Koribanics, I'm going to ask you about this. Put your prosecutor cap on. You're the former prosecutor. Are prosecutors rolling their eyes at this stuff, or are they taking these cases as a warning?
I hope they're taking them as a warning. These cases are very serious, and I think the prosecution has to be aware of what's happening, and that means they're going to have to focus a lot. A lot of times prosecutors have a tendency to think that a murder's a layup. It's an easy case. It's something they can prove easily. This is making it complicated. In this case, though, I thought the prosecution did a good job, because they showed there were some cell phone calls when they actually claimed she was dead.
Well, bottom line is it comes back to burden of proof. If the state doesn't have it beyond a reasonable doubt, then the defendant walks, and that's what happened here. I also want the panel's opinion on this week's news from disgraced actor Bill Cosby. He says he is expecting to serve his entire 10-year sentence for sex assault, despite the chance he could get out of prison after 3 years. Cosby told a reporter he has no plans to express remorse to a Pennsylvania parole board. Cosby also says people don't know the truth about what happened between himself and his accusers, that his trial was a setup, and that the jurors were imposters. Cosby appeared to be referencing a juror who said Cosby was guilty. That juror remained on the panel despite a defense objection. Cosby also said his conviction was racially motivated and that he believes too many fellow African Americans are behind bars. So now that we're all gathered here one final time tonight before the Thanksgiving holiday, Ecleynne Mercy, if Bill Cosby were your client, what would you say to him after that interview?
Stop doing interviews. Just stop doing interviews. Just shut it down, Mr. Cosby. Just stop doing interviews. You can't dictate how somebody feels, but that was like really the spur of the moment. I do not like my clients to try their case in the court of public opinion. So stop doing it.
Yeah, I mean, you know, you can complain about the parole board situation, but Mike Koribanics here, you know, if you have a serious appeal issue on the juror having a belief of guilt, then let it play out, okay? And then maybe beg for mercy in front of the parole board. Is that the best option here that he really should be taking?
Well, the best option is let lawyers do their job. I think his case has a lot of appealable issues on a procedural basis, severance, things of that nature. I thought there were too many victims in that case. But he should just let his lawyers be out front, do what they're supposed to do, take their advice, and keep your mouth shut and deal with the parole board when that comes.
Michael Bryant, your thoughts on this one? I mean, a lot of people are saying, hey, look, we need to reduce the number of African Americans behind bars. I think that might resonate with people, but is this the person to argue that the most effectively in the court of public opinion, even if he is to argue it?
He's a bit bitter, and you know, he has basically a relish plate of problems with these things that he had to say. You know, he's blasting the system, he's blasting specific witnesses, and he's basically saying, I'm not remorseful. I mean, that is a trifecta of a loser. And so whether he plays that out in front of the parole board or not, he's out there now on the record, and he's going to do more time. He's not getting out anytime soon.
Ecleynne Mercy, does it come up in front of the parole board? Final thoughts from you.
Yeah, I think it does, but again, remember, he's just an old man, and he's become a crotchety old man, and you got to let old man just talk. We forget that, you know, when you get to certain ages and life throws things in your face, that you're going to say things that aren't really helpful to your case. So I think that when people can put into consideration his age, that may help.
Ecleynne Mercy, thanks a lot for your opinion. The voice of reason from Atlanta, along with the rest of the panel. Have a good Thanksgiving to the three of you, and to those of you watching along with us. Our live coverage resumes after the holiday. We'll see you then.